Hear ye, hear ye. The Court of Appeal for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution, His honorable court.
Good afternoon. The case before us today is BMLA versus Jordan. May the parties make their announcements.
This is Lance Olin for the appellant, BLMA Inc., doing business as Murphy's Deli.
This is Kieran McAlpin for the appellee, Keziah Jordan.
Okay. And I understand Mr. Olin,
Yes, ma'am.
that you want to reserve 3 minutes. Is that correct?
That is correct.
Okay. All right. Let us begin with the issue of causation. I have looked at as all of the panel members have, quite a number of times, the deposition of our expert, Dr. Hassan, and tell me what you think about that and how it relates to the causation between the injury and Mrs. Jordan.
Okay. When Dr. Hassan first saw Ms. Jordan in the emergency room at St. Luke's, he made the clinical diagnosis of viral gastroenteritis. He then based his treatment protocol based upon that clinical diagnosis. And we learned that the treatment protocol was actually successful because she got better and was discharged. He looked at a few factors to determine whether or not she had viral gastroenteritis as compared to bacterial gastroenteritis. And he saw it significant that, one, she did not have a fever. And if she had had bacterial gastroenteritis, she would have expected a fever. Two, she did not have a significantly elevated white blood count. And if it had been bacterial gastroenteritis, she would have had that. He also looked at the fact that less than 20% of the gastroenteritis cases that he's seen, and he testified that he'd seen thousands, less than 20% typically involved a bacterial origin. And so based upon all of that, he determined that the appropriate treatment protocol for Ms. Jordan would be to treat it as if she had viral gastroenteritis.
Interrupt you for a minute, Counselor. I had one question about that. Dr. Hassan says in his testimony that the vehicle for delivery of a pathogen can be from food, and that a food can deliver either a bacterial pathogen or a viral pathogen. So here, where we have some testimony that a virus could have been on food and delivered to a person in that manner, isn't that some evidence that viral gastroenteritis could come from a food, or is that not correct?
There's no question that it can come from a food. And he testified that one type of toxin that can cause viral gastroenteritis is Shigella. And that was in his testimony. But he was asked by both lawyers, for the plaintiff and the defendant, about Staphylococcus aureus, which is basic staph, which is a bacteria. He was very clear that that staph is a bacteria and not a virus. He then was asked some questions by plaintiff's counsel about Staphylococcus aureus and whether or not it would be found in reheated foods or processed foods. And then following that question, he asked a hypothetical question based on a colostomy. And he said, would it be possible that she had contracted gastroenteritis from exposure to a staph toxin? And he said, yeah, that's possible. He didn't say that happened or a reasonable medical probability that it happened, but he said it was possible. But regardless, he continued to say that it was his belief that it was likely that she suffered from viral gastroenteritis and not bacterial.
And did Dr. Hassan ever testify that the most common cause of viral gastroenteritis is food?
I don't believe he did.
And did he ever testify that within a reasonable medical probability that the kolache would have caused the viral gastroenteritis?
Correct. Not only did Dr. Hassan fail to express that ultimate opinion that kolache Ms. Jordan ate caused her to suffer from gastroenteritis, he didn't even get close to it. And so with that backdrop, we look at Texas law as it relates to establishing causation in a situation like that and like this, which is that expert testimony is necessary to establish causation as to medical conditions that are outside the common knowledge and experience of jurors.
Can I ask you a question?
Yes, sir.
Are you suggesting that food poisoning is outside the common knowledge of jurors in Texas?
I am.
You're saying that you've never had it? You don't know what it's about? You couldn't understand it from your common knowledge?
I'm saying that in terms of establishing causation between a condition and an event in the condition, Texas law requires expert medical testimony. There are cases that say, even out of this court, that say the fact that there is a temporal relationship between the two, the event and the condition, is no evidence other than there's a relationship in time. And that's out of the Evans versus MIDITT case from 2007 in this court. And that involved I think that involved the eating of crabs that allegedly caused gastroenteritis. And on summary judgment, the court said there was no causation because all we had to look at was a relationship in time between the event, eating of the crabs, and the condition that developed after that. And we see
I had a
similar
question about one of the passages of testimony from Dr. Hassan. He says that it would take typically 2 to 3 hours for tainted food to reach the large intestine. And here, how long before she became sick did she consume the kolache?
In this case, she testified that it was approximately 30 minutes.
Okay.
When she felt symptoms of nausea, stomach cramping, and then diarrhea that led to her syncope episode at the receptionist desk. So in the cases that we cited, like Burroughs, Welcome versus Cry, the Gustavo versus Ferrar, Sanchez versus Li Hayao, which is a case out of, I guess it was an opinion authored by Justice Kelly back in December of last year, where he said there had to be medical testimony to prove up causation for medical charges and medical conditions as a result of a motor vehicle accident. There was a similar opinion, Hills versus Donis, out of the 14th Court of Appeals. The first opinion was issued back in January of last year. And then last month, they issued a substitute opinion, but it had the same holding, which was that expert testimony was needed to establish causation of the medical condition claimed by the plaintiffs, or 3 of the adult plaintiffs, that was outside the common knowledge and experience of jurors. Stated another way, expert testimony would not be needed when the conditions claimed are within the common knowledge and experience of a layperson, such that it would enable the layperson to determine causal relationship with reasonable probability. If that standard is not met, then the temporal relationship between an event and a condition establishes nothing other than a relationship in time. And unfortunately, I think that's what we had in this case, is that all the jury had was the unfortunate event of Ms. Jordan having the syncope episode at the receptionist desk, and the consumption of food some 30 minutes earlier. And there was no medical testimony that in reasonable medical probability that the consumption of the kolache led to the symptoms that resulted in her eventually fainting. After reading I read Dr. Hassan's testimony probably 6 times or more. And about the only thing that the jury could learn from that testimony was that Dr. Hassan made the clinical diagnosis of viral gastroenteritis. He came up with a treatment protocol for that, and she got better. The rest of it's highly confusing, and nowhere in there does he say that the consumption of the kolache actually caused her condition that brought her to the emergency room that day. So one of the other cases that we cited in the brief was the Smith versus Landry's case, and that involved a woman that had, similar to what Ms. Jordan testified to here, had not eaten for about 20 hours before she came to Landry's, where she consumed or ate some crabs. She experienced symptoms so significant that she had to be taken to the emergency room within less than 5 hours. She actually had a physician offer some testimony on her behalf. The physician's testimony was that based upon her presentation and symptoms, he said in reasonable medical probability, her symptoms were consistent with gastroenteritis. He also said it was more likely, again, a reasonable medical probability that she had food poisoning, considering the clinical history and setup of her condition. However, the doctor did not testify or express the ultimate opinion that the consumption of foods at the restaurant caused her to suffer gastroenteritis. And as a result, at that point, the 14th Court of Appeals determined that there was less than a scintilla of evidence on the issue of causation, that is, the consumption of the crabs and her development of gastroenteritis. And so
what would be in that particular case a factual basis that would bolster the expert testimony, could you say?
Well, they could have tested her, they could have tested her, I guess, her blood. They could have tested her, whatever she was protruding from her body, whether it was vomit or something else. And they can test and see what kind of pathogen is prominent in that substance. Typically, physicians obviously don't do that because their main concern is assuming that they can treat the patient quickly and effectively, that's all they're doing. Now,
Right.
if the patient's course of treatment takes a turn and they're still not sure what she has, then they might in fact go back and test her. But that's typically not done. That's typically why these cases are so hard to prove.
And you're saying there's no factual basis here, and because of no testing.
Correct. I mean, the doctor, I'm sorry.
Go ahead. Finish your thought.
Dr. Hassan willingly acknowledged that in his own mind, he had questions about whether it was viral or bacterial gastroenteritis and what the source of it was, even after him seeing her and attempting to treat her.
Okay, let's hear from the other side. Mr. McAlpine?
May it please the court?
Let me start you with a question. Is it your position in terms of establishing causation that this is something within the common knowledge and experience of jurors, or do we need expert testimony?
The case doesn't, Your Honor, present that due to the presence of expert testimony. I think that's an interesting question. The court has held, and Your Honor has written an opinion in Figueroa versus Davis in 2010, that where matters are within the common knowledge of a lay jury, then lay testimony can be sufficient, but that's limited to case is that the mechanism is within the common knowledge of a lay jury. The best example that I could think of would be a fall that leads to a broken foot or a laceration from a knife. In
Okay,
this
so
case,
can you,
I think it's
can you
close.
agree, can you agree with me that this case doesn't present a situation where we don't need expert testimony?
I would agree that I hadn't really considered that, Your Honor. I think it's close. I think that the critical testimony from Dr. Hassan that most likely is actually necessary in order to prove this case by legally sufficient evidence is an opinion that Dr. Hassan gave twice, which is that to reasonable medical probability, the illness that Ms. Jordan suffered from was food poisoning. It was necessary to distinguish her syncope and nausea and her other symptoms from her atrial septal defect, which is what she was in the Texas Medical Center that morning to treat to begin with. It was necessary to delineate food poisoning from other sources of illness that can also cause diarrhea and vomiting. So we think that Dr. Hassan's testimony, which he gives twice to reasonable medical probability, that more likely than not, this is gastroenteritis from food, was.
Okay, well, wait a minute. Let me stop you just a moment. It may seem harsh, and I don't mean to be that way because I think we have a very serious injury here. But I've read, and each of the panel members have spent a lot of time going over Dr. Hassan's testimony, and I think we all have copies of his testimony. So how about if you spend a minute or two pointing out exactly where you say that, he makes the case that this kolache is connected to the injury.
Well, thank you, Your Honor. The question that is one of the culminating questions that he's asked, which is that if we can prove that we can eliminate alternative sources of food poisoning from the food that Ms. Jordan ate the previous day, would you agree more likely than not that the kolache caused the food poisoning? And
okay, that's a conditional sentence. You don't disagree with that?
Your Honor, I don't disagree with that. However, an expert can answer a mixed question of law and fact. The hypothetical, those facts, if proven, can give the jury what they need in order to find for the plaintiff. And not only did Ms. Jordan's testimony establish those facts, that record is completely undisputed, and the appellant fails to mention it anywhere on this first issue at all.
Could you give me the record site where you're talking about those alternative sources?
The alternative sources.
Or the passage that you're relying on that you just told the.
Yes, I can. The record reference is, I apologize, I don't have it exactly at my fingertips.
Maybe page 16.
Okay, I can find it. It occurs in the record on the third volume of the reporter's record on page 226, lines 9 through 15.
Okay, but isn't that a response to a question about staff? It says, I believe in lines 2 through 7, now seeing as Ms. Jordan had not eaten anything prior the kolache in 8 hours, and then she eats a reheated kolache, and then in about an hour falls ill, is it possible that she had contracted gastroenteritis from exposure to staph?
Yes.
So that's talking about staph, but Dr. Hassan said she has viral gastroenteritis and not staph, right?
That was his initial clinical diagnosis, is that it is likely viral gastroenteritis.
Which would not be staph, right? That would be something different. Staph's a bacteria.
Yes. And I think it's important to point out that the discussion of viral versus bacterial is in the nature of rebuttal in this case. The plaintiff isn't required to prove the specific direct pathogen in this case. Our contention is that the plaintiff would be required to prove that it came from food poisoning. And the discussion of viral versus bacterial is something that I brought up because it provides rebuttal to the defensive theory of the case, which was that the gestation period of 30 to 45 minutes was too short for the kolache to have been a cause of the food poisoning. That contention from the appellant permeates the record. It's what Mr. Steer based his report on. It's in the closing argument, and it's throughout the record. And the important point that is being probed with the bacterial versus viral distinction is Murphy's correct about that? Can either viral or bacterial gestate within an hour? And Dr. Hassan testified yes on both counts. He testified that it can be caused that quickly within an hour if it's a toxin directly from a viral source. And Dr. Hassan testified that there are several different bacterial agents that can cause acute onset food poisoning within an hour, including the Staphylococcus aureus enterotoxin, which I focused on in part because it fit a lot of the other evidence in the case. But ultimately, the opinion that more likely than not, the source of the illness is food poisoning combines with Ms. Jordan's unrebutted factual testimony to provide a legally sufficient case of proximate cause. I think it's important to remember that unlike the Landry's, the Smith versus Landry's case, and unlike the other case that they, let me see what's the exact citation.
Could I interrupt you just a minute?
Denny's.
Oh, I'm sorry, Chief. Go ahead.
I was just saying, it was Denny's.
The Denny's case is completely distinguishable, Your Honor, because it deals only with a sham affidavit without any expert evidence. But the case.
Okay. I just thought you were trying to remember Denny's, is why I threw that out there.
Oh, thank you, Your Honor. Neal versus Down AgroSciences LLC. In both of these cases, you have a summary judgment for a defendant, and in those cases, the appellee, after there's an evidence ruling pursuant to Daubert and Robinson and Rule 702 and 703 that strikes expert opinion as unreliable. In the record below, nowhere does Murphy's object to, under 702 or 703 or Daubert or Robinson, any of Dr. Hassan's testimony. So if the record was one where either Dr. Hassan's testimony had been excluded in part or in whole, or whether there was an overruled objection that had been raised on appeal, we would be in a completely different procedural posture than we are now. And additionally,
Can you tell me just where in the record real quick that he testifies more likely than not that it was caused by food poisoning?
yes, I can. In the same third volume, page 199, lines 3 through 6.
Okay, so he says, in your opinion, is it your opinion that the viral gastroenteritis was brought about because of food? And then he says that's the typical source of gastroenteritis. Does he also say somewhere that's the typical source of viral as opposed to bacterial?
That distinction is not occurring. No, the answer is no.
Okay, all right.
And there's an additional, he repeats that opinion a little bit further down on page 202, same volume, 17 through 25, and then 23, 1 through 8. There's also the medical record from St. Luke's that says that and this is a direct quote, that patient fainted due to food poisoning at Murphy's Deli. So that is evidence that's unobjected to, that's in the record, that the jury can consider and should have considered, and any reasonable jury would have considered it. And there's also testimony that in more cases than not, is it true that food is the cause of gastroenteritis? Answer, correct. That is page 220, lines 15 through 17.
Thank you.
So, and I'd also just point out that at the beginning of the examination of Dr. Hassan, he testified that he would give all of his opinions to reasonable medical probability. And while there's hundreds of cases, and a question that Chief Justice Raddick had asked towards the end of the argument before pointed towards this, that there's hundreds of cases that say that the ipse dixit of an expert is legally insufficient. The conclusory opinion is not sufficient to raise a fact issue. And what that points to is the need to have some basis and some data and some support for the opinion. Well, Dr. Hassan gave multiple bases for his testimony. He referred to the clinical presentation with the non-bloody diarrhea, no fever, abdominal cramping, nausea, syncope, and elevated white cell count. And he
just one more question following up on that. We've got a lot of cases in this record about food poisoning, or lots of cases that the parties have cited, but I haven't seen any that were tried on this particular theory of implied warranty for a particular purpose. And usually under Texas law, that's when there's, like you go into a scuba shop and you're looking for a watch, but not just, regular watch, one that's gonna survive when you go scuba diving. And here, I mean, this is just a regular kolache, right? And so do those cases map on to this fact pattern in the same way, or?
I would point out, Justice Ferris, that there's no objection to the charge as it was submitted. Okay. So it's not before the court whether the case was tried under the correct theory. I would also say that there's no direct factual parallel case in the state of Texas. The closest parallel case that I've found is Williams versus O'Charlie's from 2012, which is from the North Carolina Court of Appeals. And I examined that case solely on the issue of causation. So that there isn't a direct parallel case. The Smith versus Landry's case is completely distinguishable procedurally and factually for the reasons that I'd stated earlier, and also the Ferrar cases as well. And I would also point out, before I forget this, that Dr. Hassan testified that testing to get a direct case of food poisoning would be both unreliable and cost prohibitive. So what Mr. Olend said towards the close of his argument about how, well, we could have proved it by testing, there's no evidence in the record that would permit Mr. Olend to make that argument. And there is evidence in the record that explains why there wasn't testing that was done. And that appears in Dr. Hassan's testimony as well. So, I mean, I do think that one way to look at this is that we have an undisputed evidentiary record. There's no evidentiary issue before the court. And we have testimony that says in multiple different ways that it was caused by gastroenteritis, and to reasonable medical probability it did. And then there's the hypothetical question that's answered in the affirmative and also supported by the factual record. So that I think it does illustrate the question, well, if we can't prove a circumstantial food poisoning case based on legally sufficient evidence based on this record, what would it be? What did we need to have that we didn't have? In terms of why we didn't have testing, there's an explanation for that's in the record. And there's no authority in the state of Texas or anywhere else that I'm aware of that would hold that we cannot prove a circumstantial case of food poisoning, that we need to have direct evidence. There's no authority for that, and it would be outside of the court's purview to opine that in the first instance in this case. So we think that ultimately the appellant's argument is a declaration. It doesn't really engage with the evidence from the trial court.
Anybody have a question? Okay, thank you, Mr. Alpine. Let's hear from Mr. Olenda.
Thank you, Chief Justice. Just going back to some of the testimony from Dr. Hassan, and I was looking at page 221, beginning at line 3, going through line 10, where it says testifying that gastroenteritis is from staff is more commonly foodborne. And Dr.
Mr. Olinda, you're not looking at us. It makes it harder to hear you. So could you start over with what you said?
Yeah, in beginning of page 221, line 3, in his testimony, he's going through line 10. He talks about gastroenteritis caused by staph. He was asked about that. And he said, and he acknowledged that it will have a rapid onset and can be as low as 1 hour. He said, yes, that's correct. And then he said, he's asked, is gastritis from staph more commonly foodborne? And he said, yes. But this is all not consistent with his testimony that he believed it more likely than not to be viral gastroenteritis. The fact of the matter is the plaintiff had the burden to prove, based on reasonable medical probability, that the kolache that Ms. Jordan consumed was a cause of her immediate symptoms and was a cause of her syncope and the injuries to her teeth and mouth, which were sad and unfortunate. But they didn't do that because nowhere in their record is their medical testimony, which is required under Texas law, that there is causation between the consumption of the kolache specifically and the resulting symptoms that Ms. Jordan suffered. So that, I couldn't hear that.
Oh, I think you're muted, Chief.
I turned it off. My clock was going off. Does anyone have any questions? Panel members, no questions. Okay, thank you both for your arguments. We are adjourned.
Thank you.
Thank you, Your